6 years ago, I signed a piece of paper that changed everything. The HOA built 312 homes on my family's land. Then their president decided my house was next. Fake violations. A forced sale notice on my door. Everyone at the meeting expected me to fold. I just sat there, folder in my lap, and smiled, because I still had one thing she forgot about. The original deed, and it said something she never read. My name is Claire Donnelly, and I grew up on 60 acres my grandfather cleared by hand outside Maple Hollow, Georgia. After my father passed, the land came to me, along with his old roll-top desk, his hunting dog, and a filing cabinet full of papers I hadn't yet learned to appreciate. I was raising my daughter Lily alone most weekdays while my husband Mark worked construction 2 counties over. Money was tight, the roof needed patching, and when the HOA next door came knocking with an offer, I listened harder than I probably should have. Maple Hollow Estates sat right against my back fence. A tidy grid of vinyl-sided houses with a clubhouse, a pool, and rules for everything down to mailbox paint. As president, Sandra Kessler, wore blazers to backyard barbecues and signed emails warmly. Sandra, even when she was furious. Sandra found me at the feed store one Saturday, complimenting my tomatoes before she ever mentioned land. She said the HOA was bursting at the seams, that families were being turned away, and that my back acreage was just sitting there doing nothing for anyone. She proposed a deal dressed up as generosity. The HOA would build Phase 2, 312 homes, on the back 40 acres I never farmed. In return, I'd get a yearly land use payment, free HOA amenities for life, and my daughter's college fund would finally breathe. I told her I needed to think it over, and she smiled the way people smile when they already know your answer. Of course, she said. No pressure at all. Then she left a bottle of wine on my porch with a sticky note that read, "Family looks out for family." My father's old attorney, a soft-spoken man named Walter Higgs, had drawn up land papers for half the county before he retired. When I brought him Sandra's contract, he read it twice, frowned, and told me the wording was sloppy enough to cause trouble down the road. Walter insisted on one change before I signed anything. Instead of selling the acreage outright, we'd grant the HOA a revocable license to build and use the land, with the deed staying in my name and a reversion clause if the terms were ever broken. Sandra balked at first, calling it unnecessary paperwork for a friendly arrangement, but she signed it anyway, eager to break ground before her term as president ended. I remember thinking she wanted this deal more than she was letting on, though I didn't ask why. Construction started that spring. Trucks rattled the fence line from 6 in the morning, and dust settled over my garden like gray snow. Sandra promised it would only take 18 months. It took almost 3 years, and somewhere in that time, the polite version of her disappeared. By the time the houses went up, Sandra wasn't just HOA president of Maple Hollow Estates. She was president of Maple Hollow Estates and Phase 2, a title she'd printed on new letterhead before the concrete even cured on the last driveway. I noticed small things first. My name quietly vanished from community newsletters that used to thank our generous neighbor. The land use payments started arriving a few days late, then a week late, then not at all some months, always with an apologetic text that promised to catch up. Sandra's husband, Gary, ran a construction firm, and I later learned, though I didn't think much of it then, that Gary's company had won the contract to build all 312 homes without a single competing bid from anyone else in the county. At the ribbon-cutting ceremony, a banner read Kessler Vision, Kessler Values. Sandra thanked the town council, the bank, her husband, even her dog. She never once mentioned whose land the neighborhood was standing on. I stood at the edge of the crowd and said nothing. My daughter Lily was 8 then, and she loved wandering the new sidewalks on her bike before the families moved in. One evening Sandra stopped her, crouched down, and said, "Sweetie, this isn't really your yard anymore, is it?" Lily came home confused and a little hurt. I called Sandra about it, calm but firm, and she laughed it off as a joke that clearly didn't land. She said I was being sensitive, that of course the land was still mine, and that I should focus on the good the community was doing for everyone. Within a year, 312 families had moved into Maple Hollow Estates Phase 2. Many of them didn't know the land had ever been anyone's but the HOA's. Sandra liked it that way. I think a clean origin story with her name at the center. I kept every signed page Walter had drawn up locked in my father's old filing cabinet, along with copies mailed to myself years earlier as extra proof, a habit Walter always insisted on. At the time it felt like overkill. Later, it would feel like the only thing that mattered. The land use payments stopped entirely the following spring. When I asked Sandra about it at a community picnic, she waved a hand and said the HOA's finances were being restructured and that the board would revisit old obligations once the new clubhouse was finished. A new clubhouse. A $2 million renovation project. The same month my payments disappeared, complete with a rooftop deck and a fountain shaped like a swan. Residents grumbled about the special assessment fees, but nobody dared question her too loudly. I started attending HOA board meetings. Not as a member, I wasn't one, since my property sat just outside the association's boundary, but as a guest who wanted answers. Sandra allowed it with visible reluctance, always seating me in the back corner near the coffee urn. At my first meeting, Sandra introduced me to the room as our land partner, a phrase that sounded generous until I realized no one there knew I still legally owned the ground their houses were sitting on. I let the misunderstanding stand, for now, and watched. The first real fight came over a drainage ditch. Runoff from Phase 2 had started flooding my remaining garden every time it rained, washing topsoil straight into the creek. I asked the HOA's engineer to fix the grading before it got worse. The engineer turned out to be Sandra's nephew, 24 years old, freshly graduated with a business degree, no engineering license anywhere in his name. He'd been hired the same month Sandra took over Phase 2, at a salary the HOA newsletter never disclosed. When I raised the drainage problem at a board meeting, Sandra reframed it instantly. Claire's garden is on HOA-adjacent land, she told the room, and any grading changes there are actually the HOA's decision, not hers. Heads nodded. Nobody checked the actual property lines. I brought a printed plat map the next meeting, showing the boundary clearly, my garden entirely on my side of the line. Sandra glanced at it for 2 seconds and said the map was outdated, though she offered no updated version and moved swiftly to the next agenda item. That week, a letter arrived at my house, not from the county, but from the HOA's newly hired attorney, informing me that my garden shed violated Phase 2 aesthetic guidelines and needed to be removed within 30 days or face daily fines. My shed was 40 feet from the nearest HOA house and had stood there since before Phase 2 existed. I called the attorney's office, and a young paralegal admitted, almost apologetically, that Sandra herself had flagged the violation and requested it be processed quickly. I wrote back, calmly, citing the original 1962 property survey and the fact that my land had never joined the HOA. The fines kept coming anyway. Stacking up in certified letters, I began filing in a growing folder I labeled, only half joking, Sandra. At the next community potluck, a few Phase 2 neighbors pulled me aside quietly. They'd heard rumors I was difficult, someone blocking improvements the whole neighborhood needed. I realized then that Sandra wasn't just fighting me directly. She was rewriting the story before I could tell my own. One neighbor, a soft-spoken nurse named Priya, admitted she'd read the community newsletter calling me an outside landowner resisting cooperation with the association. I hadn't seen that issue. Sandra had apparently mailed it to Phase 2 residents only, skipping my address entirely. I requested a copy of the HOA's meeting minutes from the month my land use contract was approved, hoping to remind everyone, officially, whose signature was actually on the original deed. The board secretary told me those particular minutes were still being finalized, months after the fact. Mark, my husband, wanted to march over and confront Sandra directly, but I asked him to wait. Confrontation was exactly the kind of drama Sandra could spin in her favor at the next meeting. I wanted paper trails, not shouting matches she could later quote out of context. So I started documenting everything, photographing the shed, the drainage ditch, every letter, every date. I mailed myself sealed copies the same way Walter had taught me years earlier, a habit that felt paranoid until Sandra gave me every reason to trust it completely. Denise Alvarez, the HOA board secretary, caught my eye one meeting and gave the smallest shake of her head when Sandra claimed the drainage issue had already been resolved amicably. Denise said nothing publicly, but she lingered by her car afterward, like she wanted to. I introduced myself to Denise in the parking lot. She was polite but guarded, mentioning only that she'd been secretary for 2 years and that some things about the books don't always add up the way Sandra explains them. Then she got in her car and drove off. The fines for my shed violation reached $4,000 that month. Technically unenforceable since I wasn't an HOA member, but the letters were designed to look official enough to scare someone who didn't know better. I imagined how many other neighbors had simply paid up. I finally called Walter, retired but sharp as ever, and read him the fine notices over the phone. He laughed, not unkindly, and said, "Claire, they can find the moon if they want. Doesn't mean the moon owes them a nickel. Send it all to me." Walter drafted a short, ice-cold letter reminding the HOA's attorney that my property was never annexed into the association, that the fines had no legal basis, and that continued harassment could constitute a pattern relevant to future litigation. He signed it with his old title, ESQ. The fines stopped within a week of Walter's letter landing on the HOA attorney's desk. Sandra never mentioned it publicly. Instead, the next newsletter simply announced, cheerfully, Phase 2 beautification update postponed, as if the whole shed campaign had been her idea to cancel. I thought that might be the end of it, a skirmish won, a line drawn. Lily started riding her bike past the new houses again without anyone stopping her. For a few weeks, the dust actually seemed to settle, and I let myself believe it was over. It wasn't over. Learning exactly how far she could push before someone like Walter pushed back, and quietly starting to look for a way around the deed itself, instead of around me. The next spring, Sandra announced a new initiative at the annual meeting, a unified boundary review to modernize outdated property lines around Maple Hollow estates, funded by a special assessment every homeowner would pay, including, she said with a smile, our land partner. Informally, I wasn't an HOA member, so I owed no assessment, but Sandra sent me an invoice anyway, marked courtesy contribution requested, a phrase clever enough to look voluntary and threatening at the same time. I set it aside, unpaid, and kept documenting. The surveyor Sandra hired for the boundary review turned out to be the same firm Gary's construction company used for every Phase 2 project. His new survey, released 3 months later, quietly shifted my property line 40 feet in the HOA's favor, right through my garden. I hired my own independent surveyor, an older man named Frank who'd worked the county for 30 years. He walked my fence line twice, checked the original 1962 markers still buried at the corners, and told me flatly that Sandra's new survey was, in his words, fiction with a stamp on it. Frank's report went to the county recorder's office, creating a formal conflict between two surveys on file. The clerk told me disputes like this could take months to resolve, sometimes longer if someone kept filing paperwork to slow things down. Sandra, turned out, was very good at slowing things down. At the following board meeting, Sandra presented her survey as settled fact, telling residents the updated boundary meant the HOA now technically bordered my remaining homestead directly, with no buffer land between us at all. A few neighbors clapped. I stood up, calmly, and told the room there were now 2 competing surveys on file with the county, and that nothing was settled. Sandra's smile flickered for half a second before she recovered, saying my surveyor was likely unfamiliar with recent GPS advancements. Frank would have laughed at that. That week, someone anonymous mailed my county commissioner a complaint alleging I'd been running an unpermitted commercial operation for my property. A wild claim, since the only business on my land was a card table where Lily sold lemonade on Saturdays. The county inspector who showed up was apologetic, admitting the complaint had come from an anonymous tip with suspiciously detailed knowledge of my daily schedule. I didn't need proof it was Sandra. I just needed to keep a folder, and my folder kept growing. Mark started losing patience faster than I did. He wanted to knock on Sandra's door and lay it all out plainly. I reminded him that every time we reacted with anger, Sandra had a story ready about the difficult landowner causing trouble for a peaceful community. Instead, I requested formally, in writing, full financial records for the HOA's Phase 2 account, citing my status as the original landholder under the license agreement. Denise, still secretary, was legally obligated to respond within 30 days. Sandra tried, unsuccessfully, to have that requirement waived. The financial records arrived 4 days late, heavily redacted, missing entire sections labeled vendor contracts, confidential. I noticed immediately that Gary Kessler's construction company appeared nowhere by name, only under a vague line item marked Phase 2 Development Services. I brought the redacted records to Walter, who flipped through them with the particular disgust of a man who'd read 1,000 HOA disclosures in his career. "This isn't an oversight," he said. "This is someone hiding exactly where the money went and hoping nobody counts carefully enough to notice." Walter suggested requesting the underlying vendor contracts directly, a right technically available to me under the original license agreement's audit clause. a clause Sandra had grudgingly signed years earlier, back when she was in a hurry to break ground and hadn't read it closely. The request for vendor contracts sat unanswered for 6 weeks. When I finally called Denise directly, she hesitated, then said quietly, "I've asked Sandra about those contracts myself, Claire. I haven't seen them either. I don't think the board has." Not really. That admission stayed with me. If the HOA's own secretary hadn't seen the contracts approving millions of dollars in construction spending, who exactly had signed off on Gary's company winning every job without competition? I started to suspect the board meetings weren't as official as they looked. I asked Denise, gently, whether she still had her own copies of meeting minutes from years past, the ones the HOA claimed were still being finalized. She went quiet on the phone, long enough that I thought the call had dropped, before saying, "I might. Let me check something first." 2 days later, an envelope appeared in my mailbox with no return address, containing photocopied minutes from a board meeting 3 years earlier, the meeting where, officially, the board had unanimously approved Gary's company for the Phase 2 contract. Denise's initials were on the copy. Sandra's were not. I compared the copy to the version Sandra had filed with the county, and the vote count didn't match. The version I now held showed 2 board members voting against awarding the contract without competitive bids. The official filed version showed a unanimous approval with those 2 names quietly removed. Someone had altered the minutes after the fact. I didn't know for certain it was Sandra herself. Not yet. But it took someone with access to the HOA's official files, motive to protect Gary's contract, and a habit of rewriting inconvenient history whenever it suited her. I made 3 copies of everything: the original minutes, the altered filing, Frank's survey, the redacted financials, and mailed 1 set to myself, gave 1 to Walter, and kept 1 locked in the filing cabinet Lily liked to call Mom's boring drawer. Sandra, unaware how much I now had escalated anyway. The HOA filed a formal notice with the county claiming my remaining homestead lot encroached on association common area per the new survey, and requested a hearing to resolve what she called long overdue boundary clarity. At the hearing, Frank's original survey and county markers carried far more weight than Sandra's version, and the county sided with me, restoring the original property line on record. Sandra called it a procedural technicality in the next newsletter, never mentioning she'd lost outright. I thought this defeat might humble her. Instead, at the very next board meeting, Sandra proposed something new, a motion to formally request I gift the remaining homestead acreage to the HOA for the good of unified community planning, citing my supposed inability to maintain it properly. The motion failed by 1 vote, Denise's, but Sandra didn't seem bothered by the loss. She thanked the board for a healthy debate and moved to adjourn, smiling the exact smile she'd worn the day she left that bottle of wine on my porch years earlier. Walking to my car that night, Priya caught up with me, glancing back toward the clubhouse. "She's not going to stop," Priya said quietly. "My cousin lived in an HOA Sandra ran before this one. 2 states over. Same story. Almost. Ask around sometime." I asked around. Quiet conversations. But eventually a former neighbor from Sandra's previous HOA in South Carolina confirmed it. Sandra had pushed a similar land deal there too, before resigning abruptly amid a state investigation that quietly stalled and never reached charges. That HOA's records, when I finally tracked them down through public filings, showed a familiar pattern: a landowner's easement slowly reinterpreted as HOA property, contractor contracts awarded without bids, and meeting minutes with names that mysteriously changed between drafts and final filings. It wasn't proof of anything in Maple Hollow. Not legally, but it told me something important. This wasn't improvisation. Sandra had a playbook, refined over years, and I was simply the latest landowner unlucky enough to have something she wanted badly enough to reach for it. I stopped thinking of our conflict as a misunderstanding that had spiraled out of control. It was a strategy, executed patiently, and I was going to need more than patience of my own to survive it. I started returning Walter's calls faster and keeping Lily closer to home. For almost a year after the failed gift motion, things went strangely quiet. The fines stopped. Sandra even waved politely from her porch one afternoon, as if the last several years had been nothing more than a string of small misunderstandings between neighbors. Lily turned 9 that spring, and for the first time in a long while, our weekends felt normal again. Bike rides past the new houses, lemonade stands nobody complained about, quiet evenings on the porch where the only sound was cicadas instead of construction trucks. Mark started talking about fixing the roof we'd been postponing for years. Now that the land use payments had resumed, sporadically but consistently enough to plan around, I let myself believe, cautiously, that Sandra had finally accepted the boundary line the county had confirmed. I still kept the filing cabinet locked and the folder growing, a habit Walter encouraged even during the calm. Karens like Sandra don't retire, he told me over coffee one morning. They regroup. Exactly where you can reach it, Claire. Always. Denise and I had become quiet allies by then, meeting for coffee occasionally, careful never to be seen leaving the clubhouse together. She mentioned Sandra had been unusually distracted lately, taking calls outside board meetings, speaking to someone she referred to only as our friend in Charlotte. I didn't think much of our friend in Charlotte at the time. Priya mentioned once that a developer had been scouting land near Maple Hollow for a new commercial corridor. Something about a big box store and a strip mall, though nothing official had been announced anywhere yet. Sandra's term as HOA president was technically up for re-election that fall, and for the first time in years, a challenger stepped forward. A quiet retired schoolteacher named Robert who promised transparent finances and an independent audit if elected. Residents seemed genuinely excited by the idea. I stayed out of HOA politics publicly, careful not to hand Sandra ammunition about outside interference. But I made sure Robert knew, privately, that an independent audit would likely uncover far more than he expected, including contracts that had never seen a competitive bid in years. Sandra campaigned hard that fall, hosting a wine and cheese town hall at the new clubhouse, complete with a slideshow crediting herself for bringing 312 families home. She never once mentioned whose original land those families were standing on. The election ended closer than anyone expected, Sandra winning by a narrow margin after a wave of late absentee ballots arrived the final week. Ballots Denise later told me she'd never actually seen processed through the normal system the board usually followed for counting. Robert conceded gracefully, publicly, though privately he told me he suspected something about those final ballots didn't sit right. Without proof, there wasn't much to do but note it and move forward, the same way I'd been noting things for years by then. 2 weeks after Sandra's re-election, a for sale sign appeared briefly on a stretch of open land near the entrance to Maple Hollow Estates. Land uncomfortably close to my property line, before it was quietly taken down again the very next morning, as if someone had made a mistake. The sign wasn't a mistake. A week later, a certified letter arrived at my house from a company I'd never heard of, Northfield Regional Development, expressing interest in acquiring adjacent parcels for what it called a planned mixed-use corridor near Maple Hollow Estates. I called the number on the letterhead and reached a friendly representative named Bill Harmon, who seemed surprised I owned the homestead lot outright. "Our records show that land as part of the HOA's future development footprint," he said. "Someone must have given us bad information." I asked Bill directly who had provided that information. He hesitated, then admitted the initial outreach had come through a contact at the HOA, specifically Sandra Kessler, who had apparently described herself to Northfield as the primary landholder representative for the entire remaining acreage. That phrase, primary landholder representative, existed nowhere in any document I had ever signed. Sandra had invented a title for herself and used it to negotiate, unofficially, the sale of land she did not own, to a developer who had no reason to doubt her. I told Bill, calmly, that I was the sole legal owner of the homestead lot, that no sale had ever been authorized, and that any further outreach needed to go directly through my attorney. Bill apologized, clearly rattled, and said Northfield would pause discussions immediately, pending clarification. Walter drafted a formal cease and desist to both Northfield and the HOA, citing the original deed, the license agreement, and the reversion clause that made clear the land had never left my ownership. He filed a copy with the county for good measure, creating an official record. Sandra's response, when confronted at the next board meeting, was smooth as ever. She claimed she'd merely been exploring options on behalf of the community, and that any confusion about ownership was an unfortunate miscommunication from Northfield's intake team, not anything she'd said herself. Denise, sitting at the secretary's table, quietly slid a printed email across to me after the meeting ended. A copy she'd been forwarded by mistake, showing Sandra's own words to Bill Harmon. The remaining acreage is fully under HOA control pending final paperwork. Let's move fast before anything changes. Before anything changes told me everything. Sandra knew exactly whose land it was. She was racing to sell it, or at least broker a deal for it, before I could do anything to stop her, banking on my trust, my patience, or simply my ignorance of what she'd been doing. I brought the email to the county sheriff's Economic Crimes Division, along with the altered meeting minutes Denise had given me years earlier, the redacted financial records, and Frank's original survey. A detective named Ramirez listened for over an hour, taking careful notes, asking sharp, specific questions. Detective Ramirez told me the case, while promising, would need more specifically, proof of intent, ideally in Sandra's own words, showing she knew the land wasn't hers and pursued the sale anyway. The email was strong, yet. Denise, when I told her what the detective needed, went pale. "There's more," she said quietly. "Sandra's been keeping a second set of books for years. Private ledger. I've seen it on her laptop, left open once by accident at a finance meeting." I asked Denise, gently, whether she'd be willing to say that formally, to a detective, on the record. She was quiet for a long moment, clearly weighing what it might cost her, her reputation, her friendships in the neighborhood, maybe even her own legal exposure as secretary. I signed things I shouldn't have, Denise admitted finally. Not because I wanted to help her hide anything. Because she told me they were routine. And I trusted her, the same way you trusted her at the very beginning. I think it's time I stopped trusting her. Denise agreed to speak with Ramirez, carefully, through her own attorney, to protect herself from any fallout for having signed documents under Sandra's direction. It was a small, brave decision that would eventually matter far more than she realized in that moment. While the investigation moved quietly in the background, Sandra, unaware how close the walls were closing in, grew bolder in public. She began referring to my homestead lot at board meetings as the pending acreage, language that made it sound like a formality rather than a fight. A new round of HOA newsletters started describing exciting future Phase 3 plans, complete with an artist's rendering of townhomes stretching across land that included, unmistakably, my garden, my porch, and the old oak tree my father had planted the year I was born. Lily saw the rendering pinned to a community bulletin board near the clubhouse pool and came home in tears, asking if we were going to lose our house. I held her and told her, as steadily as I could, that no one was taking our home. I believed it. Mark wanted to confront Sandra publicly at the next meeting, in front of everyone, and for the first time I nearly agreed with him. But Walter reminded us both, patiently, that Sandra thrived on public confrontation. It let her control the narrative in real time. Better to let the evidence speak first. Instead, I requested, formally, that the HOA remove all references to Phase 3 and my homestead lot from official communications, citing the cease and desist already on file. Sandra's response letter called my request premature, insisting Phase 3 was purely conceptual and posed no immediate legal issue. Conceptual or not, Phase 3 renderings kept appearing on the HOA website, in a slideshow at the next town hall, even printed on flyers left on doorsteps advertising future opportunities near Maple Hollow's growing amenities corridor. Sandra was building public momentum before any legal green light existed. I started attending every meeting again, sitting closer to the front this time, taking my own notes visibly enough that Sandra noticed. Her presentations grew slightly more careful when I was in the room, though never careful enough to stop entirely, as if she couldn't quite help herself. One evening, Gary Kessler approached me in the parking lot after a meeting, something he'd never done directly before. He was polite, almost apologetic, saying his company had simply bid on projects the HOA offered him, and that whatever's happening between you and Sandra isn't really my business. I asked Gary, plainly, whether he'd known the land for Phase 3 wasn't legally available for development. He hesitated just long enough for me to see the answer on his face before he said, carefully, I build what the HOA tells me is cleared to build. That's all I do. That hesitation stayed with me longer than anything he actually said. Gary wasn't the architect of this. He was, at best, willing not to ask questions his wife didn't want asked, a quieter kind of complicity, but complicity all the same. One bid at a time. Detective Ramirez called 2 weeks later with an update. They'd obtained a warrant for Sandra's HOA-issued laptop, the one Denise had described. After establishing probable cause from the email, the altered minutes, and Denise's sworn statement about the second ledger she'd glimpsed months earlier. The warrant execution happened quietly, on a Tuesday morning, while Sandra was at a hair appointment across town. By the time she returned home, Two detectives were already waiting politely near her mailbox, laptop bag in hand, asking if she had a few minutes to answer some questions. Word traveled through Maple Hollow Estates faster than any newsletter Sandra had ever sent. By that evening, half the neighborhood had heard some version of the story. Detectives, a laptop, a warrant, though almost no one, myself included, yet knew exactly what investigators had actually found. Sandra didn't attend the next scheduled board meeting, citing a family matter, and Denise, visibly nervous, ran the meeting in her place. Residents asked pointed questions about Phase 3, about the special assessments, about where exactly all that beautification and clubhouse money had actually gone. I didn't speak at that meeting. I didn't need to. The questions people asked were the same ones I'd been quietly asking for a long time, and they were finally asking them of the right person, in the right room, without me saying a word. Priya found me afterward and admitted, a little sheepishly, that she'd believed Sandra's version of events for far too long. She's good at sounding reasonable, Priya said. It's easy to believe someone who never raises her voice, even when everything she's saying turns out to be wrong. Ramirez called again a few days later, more animated than I'd heard him before. The laptop had held exactly what Denise described, a private ledger tracking payments from Northfield Regional Development, structured as consulting fees routed through a shell account in Sandra's maiden name. The payments, dated back nearly 2 years, totaled just under $200,000. All received before any legitimate sale of my land could have possibly occurred, since Sandra never actually owned it. She'd been paid, essentially, for land she was promising to deliver through fraud. Bill Harmon at Northfield, once presented with the evidence by detectives, cooperated fully and quickly, eager to distance his company from what he called, in a recorded statement, a landholder relationship we now understand was fundamentally misrepresented to us from the very beginning. Bill's statement confirmed what I'd suspected since that first certified letter. Sandra had told Northfield, repeatedly and in writing, that she held authority to sell land she'd never legally controlled, collecting consulting payments along the way while quietly working to force me off it entirely. Detective Ramirez told me, carefully, that charges were now likely wire fraud, forgery related to the altered meeting minutes, and potentially more, depending on what else surfaced in the ledger. But charges, he warned, would take time, and I needed to keep protecting my own legal position in the meantime. Walter used the moment to file an emergency motion in civil court, seeking an injunction to formally and permanently bar Sandra, the HOA board, and any affiliated developer from making further claims, public statements, or marketing materials referencing my homestead acreage as available for development. The court granted a temporary injunction within days, given the mounting evidence, ordering all Phase 3 references removed from HOA communications, immediately and scheduling a full hearing for the following month to determine permanent terms, damages, and the true legal status of the underlying land dispute. Sandra, through her own newly hired defense attorney, issued a brief statement calling the injunction a misunderstanding currently being resolved, language so familiar by now that I almost laughed reading it. It was, I realized, the same phrase she'd used for years, worn thin from overuse. The HOA board, rattled and increasingly desperate to distance itself from Sandra individually, called an emergency session. Denise, still secretary, Read the minutes of the warrant execution and the injunction aloud for the record, her voice steady even as several board members visibly paled. A motion to suspend Sandra's presidency pending investigation passed unanimously, the first unanimous vote on anything involving Sandra in years. She wasn't present to hear it, having reportedly retained a criminal defense attorney and gone quiet on every channel the board still had for reaching her. I felt something unexpected in that moment, watching from the back row again, in my usual seat near the coffee urn. Not triumph exactly, but a kind of exhausted relief. The feeling of finally being believed after years of being politely, professionally disbelieved by people who should have listened sooner. Priya approached me afterward, along with several other Phase 2 residents, some visibly embarrassed. "We should have asked more questions a long time ago," one man admitted. "It was easier to just trust her." "I'm sorry we made that easier for her. Honestly, than it should have been." I told them, honestly, that I understood. Sandra was good at what she did precisely because most people want to believe their neighbors, their leaders, their friends. That instinct isn't a flaw. It's just something people like Sandra learn to exploit, patiently, for exactly as long as it works. With Sandra suspended and the injunction in place, I finally allowed myself to believe the worst of it might be behind us. Lily's rendering fears faded. Mark scheduled the roof repair for real this time. But Sandra, even suspended, still had one card left to play, and she wasn't done yet. 2 weeks before the civil hearing, someone cut the fence between my property and Phase 2 in the middle of the night, and by morning, survey stakes marked with pink flags had appeared across my garden, spaced exactly the way Sandra's old, discredited survey had once claimed. I called the sheriff's office immediately. Deputies found no clear evidence of who'd placed the stakes, though a Phase 2 resident mentioned, quietly and off the record, seeing a car matching Sandra's description parked near the fence line around 2 in the morning. Engine running. Frank came back out, re-verified the original county markers were undisturbed beneath the new stakes, and filed a supplemental report noting the intrusion. It wasn't proof Sandra had personally done it, but it was one more entry in a pattern that no longer looked like coincidence to anyone paying attention. 3 days later, Lily's lemonade stand sign was found spray-painted over, the word trespasser scrawled across it in bright orange paint. She cried harder over that than almost anything else in the entire ordeal, and for the first time, I felt something shift from patience into something closer to fury. Mark wanted to install cameras immediately, and this time I agreed without hesitation. We had 4 installed within days, covering the fence line, the driveway, the garden, and the road. Quiet insurance against whatever Sandra, suspended or not, might still be desperate enough to attempt next. The cameras caught something within a week. A figure in a dark jacket, walking the fence line just after midnight, stopping directly at the spot where the old stakes had appeared, crouching briefly before moving on. The footage was grainy, the face obscured, but the build was unmistakably familiar. Detective Ramirez reviewed the footage and matched the timestamp to a gap in the cell tower data Sandra's phone had pinged earlier that week. Not proof beyond doubt, but enough, combined with the fence and the stakes and the vandalized sign, to add trespassing and harassment to the growing list. Sandra's attorney pushed back hard, calling the footage inconclusive and the case against his client a coordinated campaign of neighborhood gossip dressed up as evidence. Reporters from the local paper, tipped off by then, started calling my house directly, and I let Walter handle every single one. The story broke regionally that week. HOA president suspended amid fraud. Trespassing allegations over disputed 312 home development. And suddenly, Maple Hollow Estates was the kind of neighborhood people slowed their cars down to look at. Phones out, driving past the clubhouse and my fence line alike. Sandra, cornered publicly for the first time in her life, gave a single interview to a local reporter, insisting she was the victim of a jealous landowner determined to profit off a community she never truly cared about building. I read it twice, almost impressed by the audacity. The interview backfired almost immediately. Bill Harmon's recorded statement, the altered meeting minutes, Denise's sworn account, and the shell account payments were already public record by then, and reporters simply printed Sandra's quotes alongside the documented facts, letting readers draw their own obvious conclusions. Gary Kessler filed for divorce that same week, a detail that leaked through the county clerk's office almost immediately in a town small enough that nothing stayed private for long. His filing cited, among other things, financial deception discovered through recent legal proceedings, language that told its own story. I felt, watching all of it unfold from a careful distance, that Sandra was finally out of moves that worked. But cornered people, I was learning, don't simply give up. Sometimes they reach for the one thing they still control completely, the fear of the people around them. A week before the civil hearing, an envelope arrived at my house with no stamp, hand-delivered sometime overnight. Inside was a single printed photo of Lily at her bus stop, time-stamped that same morning, with no note attached at all. None needed to understand exactly what it meant. I called Detective Ramirez immediately, shaking in a way I hadn't allowed myself since this entire ordeal began years earlier. He arrived within 20 minutes, photographed the envelope carefully, and told me, gently but seriously, that this crossed a line the investigation hadn't fully anticipated yet. The cameras hadn't caught whoever delivered the envelope, but a neighbor 2 doors down had a doorbell camera angled just enough to catch part of the street. And it showed, unmistakably, Sandra's car idling near the mailbox around for that morning before pulling slowly away. Ramirez secured an emergency protective order within the day, barring Sandra from coming within 500 feet of my property, Lily's school, or her bus stop, under any circumstances. Sandra's attorney, reportedly, had not been informed of the photo delivery before it happened, and was visibly blindsided in court. I didn't sleep well that week. Mark started driving Lily to school himself every morning instead of the bus, a routine we kept until the hearing was finally behind us. It was the first time in this entire fight that I genuinely felt afraid, not for the land, but for my daughter, Priya, and several other Phase 2 neighbors organized. Without my asking, an informal rotation of parents walking each other's kids to bus stops that week. A small, quiet act of community that had nothing to do with Sandra's version of what neighborly cooperation was supposed to look like. Denise, when she heard about the photo, called me in tears, apologizing for every document she'd ever signed under Sandra's direction, even the ones that had nothing to do with any of this. I told her, honestly, that she'd done more to fix it than almost anyone else involved. The protective order violation, combined with everything else, moved the criminal case forward faster than Ramirez had originally expected. The district attorney's office announced formal charges the following week, wire fraud, forgery, criminal trespassing, and stalking, all tied directly to Sandra Kessler by name. Sandra's mugshot ran in the same paper that had once printed her Kessler Vision, Kessler Values, ribbon-cutting photo years earlier. The two images circulating side by side online within hours. An unintentional before and after that said more than any article possibly could have written. I felt, seeing that image, a strange and unexpected wave of sadness beneath the relief. Not for what Sandra had done, but for how far she traveled to get there. From a woman who once complimented my tomatoes at a feed store to someone photographing my daughter's bus stop. Walter reminded me, gently, that the sadness didn't need to compete with the relief. That both could exist honestly in the same person at the same time. You're allowed to feel for what someone lost, he said, without ever excusing what they took from you to lose it. The civil hearing, delayed briefly by the criminal charges, was rescheduled for 3 weeks later. In the meantime, the HOA board, desperate to salvage the association's reputation, voted to formally remove Sandra from any position, past, present, or future, and struck her name from every clubhouse plaque and newsletter archive. Robert, the retired schoolteacher who'd nearly won the presidency the year before, was appointed interim president by unanimous vote, tasked immediately with commissioning the independent financial audit he'd promised during his original campaign, this time with the board's full and eager cooperation. The audit, once underway, confirmed everything Denise had suspected and more. Years of inflated invoices from Gary's construction company, phantom vendor fees, and a pattern of special assessments timed suspiciously close to Sandra's personal expenses, including a lake house purchase 2 years earlier. Residents who'd once defended Sandra at meetings now stood up, one after another, sharing their own smaller stories, a fine here, a denied request there, a neighbor quietly pressured to sell a discounted lot to a buyer who turned out to be connected to Gary's company. It became clear, listening to meeting after meeting, that my story wasn't an isolated fight over one piece of land. It was simply the largest, most stubborn version of a pattern Sandra had run smaller and quieter across an entire neighborhood for years, one compliant homeowner at a time. I finally understood something Priya had told me months earlier about Sandra's previous HOA in South Carolina. This wasn't a single mistake spiraling out of control. It was a method, refined over multiple communities, and I happened to be the one landowner with a filing cabinet stubborn enough to outlast it. Bill Harmon, testifying voluntarily as part of the fraud case, confirmed under oath that Sandra had described Phase 3 as already secured in 3 separate meetings with Northfield executives, meetings that occurred, notably, before any court had ruled definitively on the land's true ownership status. The prosecution's case grew stronger with every new document Robert's audit uncovered, painting a portrait not of a well-meaning HOA president who'd overstepped once, but of someone who had built an entire second income, quietly, off fraudulent claims about land, contracts, and authority she never legitimately held. Mark, watching the news coverage grow, finally allowed himself to relax slightly, though he still drove Lily to school every morning out of habit more than necessity by then. "I think we're actually going to win this," he said one evening, and for the first time, I let myself agree out loud. I still had one thing left to do before any of it felt finished. Walk into the civil hearing myself, deed in hand, and let a judge hear directly, from me, Exactly what had happened to the land my father left me. In my own words, without Sandra's story shaping the room first. The hearing date arrived on a bright, ordinary Tuesday morning, the kind of day that felt almost insulting given everything it was about to settle. I dressed carefully, packed the folder Walter and I had built over years into a simple manila envelope, and drove to the courthouse alone. The courthouse parking lot was fuller than I expected, reporters and neighbors alike gathering outside despite the early hour. Priya waved from near the entrance, standing with Denise and Robert, all three having come, unasked, simply to sit in the gallery and watch the whole thing through. Walter met me on the courthouse steps, calm as always, his old leather briefcase looking exactly as worn as it had the day he'd first read Sandra's contract at my kitchen table years earlier. "Today," he said, "we finally get to tell the whole story in order." Inside, the courtroom filled quickly. Northfield's attorney sat stiffly near the back, having been subpoenaed to confirm Bill Harmon's earlier testimony in person, while Sandra sat at the defense table beside her attorney, thinner than I remembered, staring straight ahead without once looking my way. Gary wasn't present. Separately weeks earlier, his own company now facing scrutiny for the no-bid contracts, a separate matter working its way slowly through the county's procurement oversight office, unrelated but uncomfortably adjacent to everything else unfolding. The judge, a measured woman named Judge Alvarado, opened by reviewing the case's long history for the record, the original license agreement, the 1962 survey, the reversion clause, the altered minutes, the fraud charges, and the still pending question of my land's exact legal status going forward. Sandra's attorney opened by arguing the original license agreement was ambiguous, poorly drafted, and open to interpretation, suggesting the HOA had acted in good faith reliance on decades of informal community understanding about the land's shared use, regardless of what any single document technically said. I watched Walter's face carefully as opposing counsel spoke, and saw no worry there at all, only the quiet patience of a man who'd read that ambiguous contract more carefully than anyone else in the room, years before this moment had even become necessary. When it was our turn, Walter didn't raise his voice or reach for drama. He simply walked the court through the license agreement clause by clause, reading the reversion language aloud exactly as written, plain and specific enough that ambiguous started to sound like the wrong word entirely. He introduced the original 1962 survey, Frank's supplemental report, and the county's own ruling restoring the boundary line years earlier, establishing beyond dispute that the homestead lot had never left my ownership at any point, under any version of events either side had presented. Then Walter called me to testify, and I walked to the stand carrying nothing but the manila envelope, setting it down gently in front of me before I sat, feeling steadier than I expected given how many years this single moment had quietly been building toward. I told the court about the feed store, the wine on my porch, the phrase "family looks out for family," and how carefully Walter had insisted on the reversion clause before I ever signed anything at all, a detail I'd once considered unnecessary caution rather than the foundation everything now rested on. I described the drainage dispute, the shed fines, the altered minutes Denise had risked her own standing to share, the anonymous complaint about Lily's lemonade stand, and the slow, patient escalation from polite misunderstanding to something that eventually left a photograph of my daughter on my doorstep. Sandra's attorney, on cross-examination, tried to paint the entire conflict as a personal grudge between two strong-willed women who'd simply never learned to compromise, suggesting my own stubbornness had contributed to years of unnecessary tension that reasonable communication could have resolved much sooner. I answered calmly that I had, in fact, tried reasonable communication for years: phone calls, letters, board meetings, a folder full of documentation nobody in the room could accuse me of assembling in a hurry. The stubbornness, I said, had never been mine to apologize for. Denise testified next, describing the second ledger, the altered minutes, and her own slow realization that documents she'd signed as routine had actually been used to misrepresent the board's true votes, protecting Gary's contracts from the scrutiny competitive bidding might otherwise have invited. Sandra's attorney pushed Denise hard, suggesting she was simply trying to shift blame for her own role as secretary onto Sandra alone. Denise, visibly nervous but steady, said only, "I made mistakes trusting the wrong person. I'm not asking anyone to forget that. I'm just telling the truth now." Bill Harmon testified via the earlier deposition transcript, confirming Sandra had described herself as having full authority over the disputed acreage in 3 separate meetings, months before any court had ruled on ownership. Language Northfield's own attorney confirmed had directly shaped their initial outreach and offer. Frank testified briefly about the surveys, calm and technical, comparing Sandra's discredited version against the original county markers with the patient precision of a man who'd spent 30 years making sure lines on paper matched lines in the actual ground beneath people's feet. Priya, called as a character witness for the community impact of Sandra's public claims, described the Phase 3 renderings on the bulletin board, the newsletter language, and how many neighbors, herself included, had genuinely believed the disputed land was already legally cleared for development. By the time the morning session broke for lunch, the courtroom's mood had shifted noticeably. Reporters in the gallery typed quickly. Sandra's attorney conferred with her in hushed, urgent tones. Sandra herself sat very still, staring at the manila envelope still resting on the witness stand beside me. Over lunch, Walter told me quietly that Judge Alvarado's questions during testimony had been sharp, specific, and clearly skeptical of the defense's ambiguous contract framing. "Judges don't usually tip their hand," he said, "but she's not buying what Sandra's selling. I've seen enough of these to know." I called Mark during the break, and he told me Lily had asked, that morning before school, whether the lady who painted over my sign was finally going to get in trouble. I told her, honestly, that I thought so, and that either way, our home was safe now. She seemed satisfied with that. The afternoon session opened with closing arguments. Sandra's attorney argued for a narrow ruling, acknowledging some procedural missteps, perhaps some financial mismanagement worth internal HOA review, but insisting the underlying land dispute remained a private contractual disagreement, better resolved through mediation than a courtroom. Walter's closing argument was short, almost understated, built entirely around one simple point: every document in this case, when read honestly and in order, told exactly one consistent story, and every attempt to complicate that story had come from a single, deliberate source, sitting at the defense table. He reminded the court that the reversion clause existed precisely because he had anticipated, years earlier, that trust alone might not be enough to protect a family's land from someone determined enough to try taking it anyway. One small step, one fine, one altered document at a time. Judge Alvarado thanked both sides, noted the volume of documentation entered into evidence, and announced she would take a brief recess before delivering her ruling from the bench that same afternoon, rather than issuing a written decision weeks later. Given the clarity of the record before her, I sat in the hallway during the recess, the manila envelope in my lap, Mark's hand on my shoulder, Priya and Denise nearby, and felt, for the first time in years, something close to certainty, not relief exactly yet, but the specific stillness of finally being heard completely. Judge Alvarado returned to the bench 40 minutes later, and the courtroom fell silent almost instantly, reporters' pens hovering, Sandra sitting rigid beside her attorney, her hands folded tightly enough that her knuckles had gone pale under the fluorescent lights above the defense table. The judge began by affirming what the county had already ruled years earlier. The 1962 survey and Frank's supplemental report established the true property boundary beyond reasonable dispute, and any conflicting survey commissioned later by the HOA carried no legal weight whatsoever going forward. She then turned to the license agreement itself, reading the reversion clause aloud a second time for the record, calling its language unambiguous to the point of leaving little room for the interpretation the defense has repeatedly attempted to introduce throughout these proceedings. The reversion clause, she explained, specifically triggered upon any material breach of the agreed terms, including unauthorized third-party marketing of the land, falsified board approvals, and harassment of the landholder, all of which the evidence presented had established clearly and repeatedly over several years. Judge Alvarado ruled that the reversion had, in fact, already triggered, meaning the HOA's continued use of the developed portion of the land was technically unauthorized from the moment of breach forward, exposing the association to potential damages for every month of use since that point. A murmur rippled through the gallery. Sandra's attorney rose immediately, requesting clarification on what this meant for the 312 families already living in their homes, a question the judge addressed directly and carefully, aware of exactly how much was riding on her next words. The judge clarified that the ruling did not evict any homeowner or threaten their individual property rights, since those sales had occurred through legitimate title transfers between the HOA and each buyer. The dispute, she emphasized, was between me and the HOA association itself, not innocent third-party homeowners. Instead, she ordered the HOA to negotiate, within 90 days, a formal retroactive land use settlement compensating me fairly for every year of unauthorized use since the breach, with terms to be determined through mediation, backed by the threat of a court-appointed valuation if good faith talks failed. She further ordered the immediate and permanent removal of any remaining Phase 3 plans referencing my homestead lot, made the earlier injunction permanent, and formally acknowledged the protective order already in place, folding it explicitly into the final judgment for the civil matter. Then Judge Alvarado turned her attention directly toward Sandra for the first time since testimony had ended, her tone shifting from procedural to unmistakably pointed. "The court finds it necessary to note," she said, "the extraordinary pattern of conduct documented in this case. By name, she listed it plainly: the altered meeting minutes, the fabricated survey, the unauthorized negotiations with Northfield, the falsified violation notices, the anonymous complaints, the vandalism, and the photograph left at a family home targeting a minor child, describing the pattern as calculated, sustained, and deeply troubling. This court," she continued, "does not make findings in the pending criminal matter, which remains properly before another court. But civilly, the record leaves no ambiguity about who bears responsibility for years of harm inflicted on a family that acted, at every turn, in demonstrable good faith. Sandra's attorney requested a moment with his client, and the judge granted a brief pause. I watched Sandra lean toward him, whispering something urgent, her composure finally, visibly cracking in a way I hadn't seen since the very first meeting where she'd called me her land partner. When proceedings resumed, Sandra's attorney requested the court seal certain financial details to protect ongoing settlement negotiations, a request the judge denied outright, noting the public record already included most of the relevant figures through the criminal case filings anyway, minimizing any real benefit to sealing anything further. The judge then addressed the HOA board directly, represented separately by their own newly retained counsel, ordering full compliance with the 90-day settlement timeline and formally noting the board's own liability for having enabled, through inaction, years of documented misconduct under Sandra's leadership. Robert, sitting in the gallery as interim president, nodded firmly at this, already having prepared, quietly, contingency plans for exactly this outcome based on what the independent audit had uncovered weeks earlier. The board, he later told me, intended full cooperation from the very first day. As the hearing adjourned, reporters surged toward the courthouse steps, and I found myself, for a strange moment, standing directly across from Sandra in the hallway, neither of us moving, both of us simply looking at each other for what felt like the first honest exchange in years. "I never meant for it to go this far," Sandra said quietly. Not quite an apology, not quite anything else either. I thought about the wine on the porch, the smile at the feed store, the photograph of Lily at the bus stop, and simply said, "I know you didn't plan to get caught." She had no response to that. Her attorney guided her gently toward a side exit, away from the cameras, and I turned to find Mark, Lily's small hand already tucked into his, having come straight from school pickup to be there for whatever the outcome turned out to be. Lily asked if it was over now, and I told her, honestly, that the land part was mostly over, though there was still the criminal case ahead, still details to settle, still paperwork Walter would spend weeks finalizing. But the biggest, scariest part, I told her, was genuinely behind us. That evening, the local news ran the story as its lead segment. The same reporter who'd once written about Kessler vision, Kessler values now reading. The judge's findings aloud on camera. The phrase calculated, sustained, and deeply troubling repeated across every outlet covering it by nightfall. Denise called that night, crying again, but differently this time, relief rather than fear. "I keep thinking about how close I came to never saying anything," she told me. "I'm glad I finally did. I just wish I'd trusted myself enough to do it years earlier." Priya organized, entirely on her own initiative, a small gathering at her house the following weekend, inviting neighbors from both the original neighborhood and Phase 2, describing it simply as a chance to actually get to know each other, now that we're not all being managed by someone's version of the truth. I went, hesitant at first, and found the gathering surprisingly warm. Families I'd only ever seen at tense board meetings now asking genuine questions about my father, about the land's history, about Lily's lemonade recipe, treating me, finally, as a neighbor rather than an obstacle or a talking point. The criminal case against Sandra moved forward over the following months, the wire fraud and forgery charges building on the civil findings. Prosecutors adding additional counts related to the shell account payments once forensic accountants finished tracing the full path of Northfield's money through it. Gary's divorce finalized quietly around the same time, his construction company facing its own separate reckoning through the county's procurement oversight review, which ultimately barred the firm from bidding on any public or HOA-adjacent contract for 5 years, a professional consequence entirely of his own making. Sandra's defense attorney, facing the weight of documentary evidence and Denise's cooperation, eventually opened negotiations for a plea deal, hoping to avoid the maximum exposure a full trial with all the accumulated evidence would almost certainly have brought against her at sentencing. I wasn't required to testify again for the plea hearing, but I chose to attend anyway, sitting quietly in the gallery beside Mark, wanting to see, in person, the moment this entire chapter of our lives finally reached something resembling an actual conclusion, rather than another delay. Sandra pleaded guilty to reduced charges of wire fraud, forgery, and criminal trespassing, the stalking charge negotiated down given the single incident, though the protective order remained permanently in place regardless of the plea's final terms, a detail the judge insisted on preserving without exception. The sentencing judge, a different one than Judge Alvarado, imposed 18 months, largely suspended given no prior record, alongside 5 years of probation, mandatory restitution to me personally, and a formal ban from serving on any HOA board or similar community association anywhere in the state. It wasn't the dramatic downfall a courtroom drama might have written. No handcuffs led away in front of cameras, no gasping crowd. Just a quiet, procedural ending to years of quiet, procedural harm, which felt, in its own strange way, exactly fitting for how it had all begun. Sandra spoke briefly at sentencing, finally offering something closer to an actual apology, acknowledging she'd let ambition and fear of losing her standing in the community push her toward decisions she now recognized, she said, as indefensible, regardless of how reasonable they felt to me at the time. I didn't feel triumphant hearing it. Exactly. I felt, mostly, tired in the specific way that comes from finally setting down something heavy you'd been carrying so long you'd nearly forgotten what it felt like to walk without it. Mark squeezed my hand. Lily, waiting outside, just wanted ice cream. The HOA's court-ordered settlement negotiations concluded within the 90-day window, Robert's board offering a fair retroactive land use payment covering every year since the breach, plus an ongoing annual agreement going forward that finally reflected the actual value of the land the community had been built on. Walter negotiated the final terms carefully, ensuring the agreement included updated language even stricter than the original, clear boundaries, automatic penalties for any future unauthorized marketing or misrepresentation, and a requirement that any changes require my written consent, notarized, with no exceptions for informal understanding of any kind. Robert's board also commissioned a full public accounting of the beautification fund and clubhouse renovation costs, revealing nearly $300,000 in inflated invoices tied to Gary's company over the years. Money the board began the slow process of recovering through separate civil claims of its own. Denise, despite everything, was asked by several residents to run for HOA secretary again in the next election, a request she initially declined out of guilt, before eventually agreeing, telling me she wanted the chance to do the job the honest way, now that she finally knew what dishonest looked like up close. The Phase 3 renderings came down from the community bulletin board permanently, replaced eventually by a simple, framed copy of the county's boundary ruling and a short plaque. Robert insisted on adding, "Reading only, boundaries matter. Ask questions." Nobody needed further explanation of why. I finally allowed the HOA to formally acknowledge, in writing, whose land the community's park space technically bordered, not out of any lingering resentment, but because Lily deserved to grow up in a neighborhood where the truth about her own family's history wasn't something anyone felt the need to hide. Priya's gatherings became a regular thing, monthly potlucks rotating between houses on both sides of the old fence line, which Mark eventually took down entirely, replacing it with a simple gate Lily insisted on painting bright yellow. So everyone knows it's a friendly one now. Bill Harmon, before Northfield fully withdrew from the region, sent a formal apology letter along with a modest goodwill payment, acknowledging his company's role, however unwitting, in nearly facilitating an unauthorized sale of land that was never legally available for development in the first place. Gary's construction company, barred from public contracts for 5 years, quietly downsized, eventually selling off most of its equipment. I felt no particular satisfaction in that specifically. His complicity had been real, but quieter. A man who'd simply chosen never to ask the questions his wife didn't want answered. Sandra sold the lake house that had first caught Robert's audit's attention, using part of the proceeds toward the court-ordered restitution payments, which arrived, according to Walter, in small but consistent monthly installments over the following years, exactly as the sentencing terms had required. I never spoke to Sandra again after the sentencing hearing. I heard, eventually, secondhand through neighbors, that she'd moved out of state entirely, taking a quiet administrative job unrelated to real estate or community management of any kind, the HOA ban following her wherever she went next. Denise told me once, months later, that she sometimes still felt guilty for how long it took her to speak up, and I told her what Walter had once told me. The sadness and the relief could exist together honestly, and neither one canceled out the courage it eventually took her to choose differently. Robert's board finished its first fully transparent fiscal year, publishing every expense, every vendor contract, every bid, in a newsletter that finally lived up to its old cheerful tone honestly instead of as a cover for something else. Residents actually read it now, cover to cover, every month. Lily's lemonade stand became something of a neighborhood tradition. Phase 2 kids joining her most Saturdays. The spray-painted sign long since replaced with a new one Mark helped her paint. The word trespasser, nothing but a story she'd tell. Someday. About a summer she barely remembered clearly. I kept the manila envelope, though its contents eventually moved permanently into a proper safe deposit box at the bank. Walter's old habit of mailing myself. Sealed copies finally retired, replaced with something a little more modern, though I still smiled every time I thought about why we'd needed it at all. Walter retired fully the following spring, handing his remaining files to a younger attorney in town, though he still stopped by the house occasionally, mostly for Mark's cooking, always asking, half joking, whether anyone's tried to steal your land again lately, Claire. The answer, thankfully, stayed no. The land itself, the part still legally and fully mine, stayed exactly that, mine, quietly, ordinarily, the way it always should have been from the very beginning. Long before a woman with a bottle of wine and a phrase about family had ever knocked on my door at all. I thought, sometimes, about how easily this could have gone differently. If Walter hadn't insisted on that reversion clause. If Denise hadn't found the courage to speak. If Frank hadn't kept walking fence lines the honest, careful way for 30 years before anyone ever needed him to testify. It wasn't luck exactly that saved us, though luck played its part. It was paperwork, patience, and a handful of people who chose, eventually, to tell the truth even when it cost them something real, a friendship, a reputation, a marriage, a career built on contracts that shouldn't have existed. 312 families still lived on that land. Their homes theirs fairly and legally, and I never wanted to take that away from any of them. I only ever wanted what was mine to remain mine, and in the end, the paperwork my father's old friend insisted on made sure it did. A year after the sentencing, Robert invited me to speak at the HOA's annual meeting, not as a landholder or a plaintiff, but simply as a neighbor with a story worth telling honestly. For once, without anyone rewriting it before the ink even dried on the minutes. I stood at the podium where Sandra had once thanked her dog before ever mentioning whose land the community sat on. And I told the room, simply, about my father, about the reversion clause, about Denise's courage, and about how boundaries, when respected, protect everyone, not just the person who drew them. Afterward, families I'd never spoken to before came up one by one, thanking me, some quietly, some tearfully, for holding a line most people would have given up defending years earlier out of simple exhaustion. I told each of them the same thing. I only had one job, which was to keep the paperwork. Lily, 12 now, sat in the front row that evening, watching me finish, and afterward told me she wanted to be a lawyer someday. Like Mr. Walter, but with better shoes. I laughed harder than I had in years, and thought, for the first time in a long while, that we were truly fine. The yellow gate stayed open most days. Kids from both sides of the old fence line running through it freely. The land finally doing exactly what land, like that, should always do, holding a community together honestly, instead of quietly being stolen out from under the family who'd always cared for it. People still ask me, sometimes, if I regret signing that first agreement with Sandra all those years ago, letting the HOA build 312 homes on land my father had left me. I tell them, honestly, that I don't, not because it was easy, but because it was fair. Once the truth caught up, what I regret, if anything, is how long it took most people around us to believe a quiet woman with a filing cabinet over a confident one with a smile and a title. A lesson I hope Lily carries with her long after she's forgotten the exact details of any single afternoon in court. I still have that deed, safe now, exactly where it belongs, and every so often I take it out, just to remember that paper, patience, and the truth, kept carefully enough for long enough, can outlast even the most convincing person determined to write you out of your own story. The END.